All right, welcome everybody to our Constitution Day event. We're paused there for a minute to let people come into the event from the virtual waiting room, but it looks like we've got our participants here. So I'm Dr. Carson Holloway. I'm chair of the Department of Political Science. Welcome again to everybody. It's customary and also lawful, required by law, that institutions that receive federal funding do programming for Constitution Day to educate students and faculty and staff and everyone in the larger community about the Constitution and about issues relating to the Constitution. So this year, we're very pleased to have as a presenter the Political Science Department's own Professor Brett Kyle, who is going to speak about the topic of a book that he published recently with a co-author. The title of the presentation and the book is Military Courts, Civil Military Relations and the Legal Battle for Democracy, subtitled The Politics of Military Justice. So that's what we'll be hearing about in just a moment. I do want to make this brief programming announcement at the beginning. There is a feature whereby you can pose questions at the bottom of the screen, Q&A. So if you have a question as the lecture is proceeding, Professor Kyle won't stop on the spot to answer it, but if you enter your question, it will go into a queue and we'll be able to see it and we'll address questions at the end of his presentation. So please do share your questions and they'll go to where we can see them and try to answer them. All right, I will take up no further time and I'll turn it over to Professor Kyle.
All right, good afternoon, everyone. I think I've successfully unmuted myself there. If I haven't, somebody please let me know. So first, let me say thank you to Dr. Holloway for inviting me to speak with you today, and to Courtney for organizing the event, and to thank all of you for coming. It's good to be with you. So I'm going to be speaking with you today about military justice systems, drawing especially on my new book, the title of which you see on the screen here. I'll begin today's talk by describing military justice and telling you a bit about the origins and motivation of this project, which will give us a segue into how this relates to Constitution Day in particular. And finally, I'll share with you some of the specifics of the research and findings from the book. But before I get too far into this, I want to first acknowledge my co-author, Dr. Andy Reiter, who you see pictured on the screen there, Associate Professor of Politics and International Relations at Mount Holyoke College in Massachusetts. So while I will be presenting to you today solo, this is a fully co-authored work. And speaking of the authors, this is a good opportunity for me to issue our usual disclaimer when we do these talks that we are not lawyers. This is a political science research project on military legal systems. This is the first work of the first comprehensive study of its kind in our field. So it makes a really valuable contribution to understanding military justice. And it takes this new approach of looking at military justice through the lens of politics and especially civil military relations, rather than some of the work that has been done previously that is a more legalistic approach. So I'm excited to share this with you. So to begin, militaries very commonly maintain their own codes of justice and court systems to enforce them because they are necessary to maintain good order and discipline in the armed forces. Military codes of justice include provisions for things like desertion or being absent without leave, going AWOL, right, is the kind of colloquial term for it often is used, or other disciplinary offenses that don't have an equivalent in the civilian world. If a civilian doesn't show up to their job, they're probably going to get fired. But that's likely to be the extent of the consequences to that person. They're not going to be prosecuted for not showing up to their job. If the same thing happens in the military, a soldier doesn't show up for work, that's an offense, that's a crime, and they can actually be prosecuted and have legal consequences. So there is a legitimate need for militaries to have their own court systems, and we acknowledge that. But they can be problematic, where militaries extend their jurisdiction, the jurisdiction of their courts over all crimes committed by their personnel. They can become a shield of impunity, preventing personnel from being held accountable when accused of regular crimes or indeed human rights abuses. One country that we write about at length in the book is Indonesia, where despite democratization and significant reforms of the military in other areas, such as removing active duty officers and military personnel from positions of government, they're no longer able to serve as governors or as members of local parliaments and so on. Despite those kinds of reforms in the country, the military has stubbornly resisted giving up its legal powers. And so it still has basically full control over any legal proceedings involving its personnel. Military justice can also be problematic when its courts extend their jurisdiction over civilians, as has been the case in a country like Pakistan at many times in that country's history. Most recently, after a 2015 constitutional amendment, which gave the military the power to put civilians on trial for terrorism-related charges, and to do so in secret with military officers with no legal training serving as judges. And again, this is a country that we write about at length in the book. That constitutional amendment, just to kind of bring us forward in time a little bit, that constitutional amendment in Pakistan was renewed in 2017 and then expired finally in 2019. So as of today, military courts do not have the power to put civilians on trial there. And this is emblematic of this back and forth of military legal powers in the country that it's gone through since independence in 1947. So military courts are a very important aspect of these key principles of modern democracies: the rule of law, respect for human rights, and civilian control of the military. They sit at the intersection of all of these things, and yet, by and large, political scientists have not really grappled with these questions before. And this brings me to a comment about the motivation and origins of this project. And since I'm just going to be talking for a little bit here, I might stop the screen share so that we can change things up. The slides will go away for a couple of minutes here. And just to describe for you a little bit about the motivation and the origins of this project, and then to transition into talking about the framing of this as a matter of constitutions and relations and relating it to Constitution Day. This began many years ago when my co-author and I were working on issues of accountability for human rights abuses in Latin America, and recognized that frequently the first step in actually mounting a successful trial to address past wrongdoings of crimes that were committed during military dictatorships, the first step often was getting the case out of the hands of the military and into a civilian venue in the first place. So it was clear that this was something which was very important in transitional settings, especially. There would be really no opportunity for these kinds of trials of past abuses if the military still had control over them. But this also opened up a question that was just as interesting to us in the present day, which was what venue, military or civilian, had responsibility to try violations. Had countries reformed these practices since their transitions to democracy? So we published 2 articles specifically on Latin America, and then began the global project that was larger in scope in terms of geography and time and institutional context, which brings me to the specific tie-ins to Constitution Day. And I have 2 really key points to make regarding framing the topic of military justice as a constitutional issue. The first is that we should remember that military law is still law. In a functioning democracy, military law is created by and comes from the civilian government, which draws its authority from the country's constitution and answers to the voting public through elections. So it should be possible to trace that line from this specialized court system back to the people. That's popular sovereignty in action. And as a matter of democratic civil-military relations, this is the whole ballgame. For democracy to exist, the military has to answer to civilians and not the other way around. And the authority to do any of this comes from the Constitution. Second, from our historical approach in this study, it's clear just how important the development of military law has been to the development of the modern European state and the evolution of constitutional authority going back hundreds of years. In pre-modern Europe, military commanders typically had sole authority to discipline their troops. There weren't necessarily any legal codes at all. And to the extent that they existed, they were most often temporary articles of war that the monarch or sovereign in some respect issued only in times of war. As militaries professionalized over time, however, so did military justice. Governments codified rules and developed specialized institutions and procedures to judge cases and dispense penalties. Militaries are key institutions of the modern state. They require extensive organization and bureaucracy just to function and to manage them. So by their very nature, a good deal of state building as far back as the 17th and 18th centuries was centered on the construction of militaries to defend national territory. As these became standing armies and also grew larger and larger, these proto-states were faced with a twofold imperative to develop military law. The first being the need to maintain order in those forces and prevent them from turning into a threat to the state itself. That's a perpetual dilemma of civil military relations, one that every country faces to this day. And the second being the need to, quote, make military service tolerable to the masses, as international relations scholar Everett Dolman puts it. Judging offenses could not be so arbitrary and punishments could not be so harsh that the rational thing to do when called upon to serve would be to run away, to avoid service at all, or to desert after running afoul of military regulations and laws. So this transformation of the nature of defense in early modern Europe from knights who were loyal to a to a local lord, local watches in isolated towns, temporary militias, that transformation of going from that form of kind of patchwork defenses and so on to professionalized standing armies that we would recognize today drove the development of military law. And it's emblematic of the rationalization of punishment that can be seen in other areas in that same time period as well, eroding the legal privileges of clergy, for example, or eroding the privileges of different economic guilds to decide what happens to their members if they violate some sort of rule. So this kind of aggregation of state power it can really be seen in across the board in lots of different domains. And the kind of curious thing about the military element of this is that the military power to judge itself is one of those few vestiges from that time period that we can still see in the modern era. But this development of the very notion of equal application of the law was a really important transformation, and one that we expect today, and is this kind of starting point for understanding why we would expect military personnel to be judged by civilian authorities for crimes that exist in the civilian world. So that, rather than being judged on the basis of who they are, they're being judged on the basis of what crime they're accused to have committed. So I will fire up the screen share again here. It's back to, okay, hopefully that's back up and running correctly. So specifically for our book, what we're interested in understanding is the degree of what we call legal subordination of the military to civilian authority in countries around the world. We were interested in knowing what variation exists around the world and why it exists, and then to understand how and why change occurs, both positive change in the sense of reform, and then negative change in the sense of backsliding. So I will share with you now some of the specifics about the research that we did, talk about the kind of categorization of countries by country year, and then present to you some of the results. And so to start off, I'll show you the typology of military legal subordination that exists in 3 different categories. And it lines up with the way I just described that, those examples of Indonesia and Pakistan, whereby there are circumstances under which a military can have total control over any legal proceedings involving its members. but not have control over civilians, not be able to put civilians on trial, and then a further negative category, or what we consider the worst category, of being one in which the military is able to actually put civilians on trial. So, this three-part typology, these three different types, are what we call full subordination, characterized as military courts trying members of the military for offenses necessary to maintain good order and discipline. Military courts do not try civilians. Jurisdictional contestation, where essentially there is overlap and the two are often in competition with each other, these two powers. Military courts try members of the military for offenses necessary to maintain good order and discipline, and some civilian crimes, including human rights violations. Military courts do not try civilians. So these two can come into conflict with each other, but civilians are not under military authority. Military overreach, what we call military overreach, is that final category where military courts have expansive powers to not only have total control over their own members, but also over civilians for, at least for some crimes. The power of military courts here we're defining as essentially any power over civilians, any way in which a civilian could wind up in a military court in this way, in a routine process, is what we consider military overreach. There are always, basically every constitution has some sort of provision for special circumstances, extreme circumstances, times of war, and so on. That's not really what we're considering here, but this is the kind of expansion of military power under these more routine circumstances for, as I described with Pakistan, something like terrorism-related offenses and the like. So the countries that we were looking at in order to build this comprehensive look at military legal power across the world was to look at any country that was nominally a democracy at any point during the third wave of democratization, so 1974 onward. If the Polity 5 dataset considered it a democracy even for 1 year within that time period, it became one of the countries that we were interested in. But because countries are not necessarily, they move back and forth between being democracies and not being democracies, we were oftentimes looking at countries like Thailand or Pakistan that had gone back and forth between being civilian democracy and being military dictatorship, and therefore we're capturing authoritarian periods as well. Also, we're selecting countries to come into the data on the basis of being a democracy in this modern period. But as I was referencing with regard to the sort of early modern Europe and so on, we were looking at any of these countries essentially as far back as we could track them. And so for European countries, that's potentially centuries. For other countries, it's into the period at which they got their independence from a European colonial power. So, plenty of countries entering the data in the 1960s, others at other times, going back to Latin American countries that would have been entering in the 1800s. So let's see, yeah. And then in order to judge what we're seeing here was to incorporate in our research not just the laws on the books, but also state practices. So we're looking at constitutions, military codes of justice as the written letter of the law, but then also consulting news reports, secondary literature, Human Rights Watch reports, other NGOs and activists' records and so on of state practices in order to see what this looks like in as it's actually happening, not just what's written on the page. And then to give you a sense of what this means in terms of what the data looks like and what an example country looks like. Looks like, okay, I was going to say, that should say Argentina somewhere up there. So to give you an example here, I'll use the country of Argentina, which from the point at which it gained its independence from, or declared its independence from Spain, it essentially continued with the military legal code of the Spanish Empire up all the way through, as you see there, 1973. And so it was in this jurisdictional contestation period from 1974 to 1982, while the country was fighting what it called internal subversion, which is to say fighting leftist guerrillas, and through military rule, the country is characterized as military overreach, and then jurisdictional contestation again after democratization in 1983 up to 2008, when the country abolished its military courts, and now everything is just under civilian authority. So from 2009 onward, the country is considered full subordination. A country does not have to abolish its military courts, though, to be what we consider full subordination. One other important point to make here about the nature of the cases that we're looking at is that we're looking at the essentially the domestic deployment, domestic use of militaries within their own countries, and so conditions of civil war, conditions of attempting to fight terrorism, and that sort of thing within the borders of the country is what we're really talking about here with regard to the powers of military courts. This is not a project about international deployment or warfare abroad. So the kinds of engagements that the United States has been engaged in Iraq and Afghanistan and so on, those kinds of actions invoke a whole different set of law, international law, laws of war, and so on. And so that is not the focus of this project. This project is about these kinds of domestic deployments, domestic uses of the armed forces in each country. There is a lot of literature on those other phenomena of the way that the militaries conduct themselves and accountability for those kinds of offenses and the like, which is again not the focus of this. So I'm going to show you the results at the most aggregate level here in a moment to show what every country in the world, percentage of countries around the world, and the categories of each of these different types of military legal subordination, military legal power look like over time. We also have these broken down by region, but I'm going to, just in the interest of time, I'm going to show you only the one for the entire world before then summarizing some of the key findings. So this is a depiction of global trends of those three different categories. You see military overreach pictured in black at the very top of the graph, jurisdictional contestation in the dark gray, and then full subordination in the lighter gray at the bottom. And this shows the percentage of countries in the world because the number of countries changes over time. And so this allows you to have a normalized accounting over time because, again, that bottom axis shows the timeline from 1800 all the way up to 2017. So we can see some kind of key takeaways here, which first is that there has been improvement over time. So if we're looking at full subordination, that one along the bottom, we can see that things are actually better than they have been in the past. That said, there are some of these notable blips, especially around World War I, World War II. You'll see military overreach growing in each of those time periods. And then full subordination only sort of recovering in that interwar period and indeed jurisdictional contestation, but both of those kind of recovering in the interwar period and then after World War II. And then again, you see this dramatic improvement in the post-Cold War era. So roughly 1990 and into the 1990s, there's improvement. You see full subordination rise to some degree there. But also we can recognize that there is still today the persistence of problematic systems in a significant percentage of states around the world. anywhere from about 20 to 25% still as jurisdictional contestation, and then probably another 10% or so, as you see depicted on the graph, as military overreach. So we have these key findings. As I say, military legal subordination has improved over time. And along with that, we can say that greater legal control equals better democracies and more respect for human rights. We find a positive association between military legal subordination and these other outcomes of interest, such as quality of democracy and human rights outcomes. I can talk a bit about how we, the actual data we were using to do that, but just in short, we can say that we're using the polity data, and so higher scores of democracy are associated with our scores of, the higher rates of full subordination as well. And then human rights practices and the rule of law based on political terror scale scores and Freedom House scores. Those are also countries that have higher levels of military subordination. The reverse, however, is also true, where the use of military courts against civilians coincides with the use of other forms of state repression. So we find especially bad human rights records in places with military overreach systems and jurisdictional contestation systems. And that's especially important because it means that not only are there records of human rights abuses being more commonplace or more intense, but also there is less likelihood that there will be accountability for those violations. So those are the key findings of the overall data that we constructed in categorizing countries around the world. I'll use this last 10 minutes before we transition into question and answer, though, to give you a little bit of a sense of the causal explanations that we put forward in seeking to explain not just what things look like as a static observation, but also what explains change over time and the creation of different legal systems in these different categories. So we conceptualize reform and backsliding in this way, where we have each of those three same categories that I just showed you, that I just gave you the definition for: military overreach, jurisdictional contestation, full subordination, and then recognize that it is possible for a state to move either direction along this spectrum. It is possible for a country to improve. It is possible for a country to get worse in these practices. And we also observe that it is possible for these kinds of reforms to happen, as you see depicted in those first two parallel lines. At the top of reform, this positive movement, it's possible for that to happen kind of all in one swift episode of change, such as democratization, the end of military rule, or the end of some other form of authoritarianism, where there's this opportunity to reform basically all institutions of the state. And those are circumstances in which we can observe that things get better kind of overnight, at least on paper. Maybe there are challenges after that, but the kind of institutional change that happens very rapidly. It's also possible, however, to see some reform that kind of peters out or doesn't make it all the way. It just makes it to this point where, maybe civilians are no longer under military legal authority, but the system never makes it all the way to full subordination. And again, that sort of mirror image at the bottom of seeing the potential for there to be backsliding that happens very rapidly, or partial backsliding that can happen over time, or something where the practices sort of get stuck in the middle. With just the kind of brief explanation of those in terms of the challenges associated with them that bring on those kinds of episodes of backsliding, they're almost always security related, or indeed an instance in which the democracy itself is overthrown. But oftentimes security related in terms of a country attempting to take on terrorism or some sort of internal conflict that upends their system that otherwise would be in place. country studies, won't elaborate on those at the moment, but I'm happy to talk more about individual country studies that we looked at as the case study chapters, maybe in the Q&A. But I'll begin with this about the patterns that we observed in terms of the establishment of military justice systems, and then the kinds of changes that were possible after that point. But we noticed essentially three major patterns in terms of how a state arrived at its initial or first military justice system. And for many countries, these were longstanding European democracies that did not really engage. The military was not especially politically powerful, not a major national institution that would have been called on to fight in lots of conflicts or to have domestic power. And so oftentimes these European democracies like Norway or Sweden started out as full subordination, and they've never really experienced significant problems with their military justice systems. Not every European democracy conforms to that, but many of them do. Then the second grouping in terms of this pattern of establishment comes also from Europe, but in a different sense. Many of the European colonial empires, Spain, Portugal, the United Kingdom, France, had very important, politically important and otherwise militaries that were a significant part of their colonial enterprise. And with the exception of the United Kingdom, most of these, because of that political role and governing role that militaries played in, potentially at home and then also in the colonies, they tended to be in the jurisdictional contestation or military overreach categories. So an empire like that of Spain, was in the jurisdictional contestation category for most of its history. And it meant that its Latin American colonies also were in that position when they gained their independence at the beginning of the 19th century. And so we see this kind of continuity in many newly independent states that came out of colonialism, just adopting the institutions and laws of their predecessor states. Oftentimes in a very literal sense of not even changing it or not even bothering to write a new law for a few years at a minimum, and just sort of having the understanding that, well, this practice exists and continues, and we're sort of operating on a law from a government that we no longer recognize, but that's the long and the short of it. But as I say, the United Kingdom is the exception to this, and so most colonies that came out of British colonialism started out at least as those in a full subordination category, and then may have changed after that, but at least at the beginning were in that kind of positive category. The next category, next pattern that we see is this state reformation, especially after the dissolution, the end of the Cold War, dissolution of Soviet Union and Yugoslavia in the 1990s, whereby there was actually a surprising amount of reform, because despite the fact that these countries were coming out of one-party state experience where communist government was certainly not a great predecessor to establish, to set the stage for strong democracies, but because the Communist Party in these places had deep control over the military, it meant that the military was not especially politically powerful in the transitional period or after the transitions, and so reform of the legal prerogatives was relatively uneventful, or was something that did not involve a lot of pushback from those militaries. And then this final one is a little bit of an outlier, but an important one to acknowledge nonetheless, as maybe a hypothetical category in large part, but also one that has a few significant cases. a post-war foreign imposition whereby Germany and Japan post-World War II, for example, and Panama after the American invasion in 1989, the United States, actually in all three cases, was the one to essentially say, okay, your old system no longer exists. Here is a new system for everything you're doing. And so that post-war foreign imposition that comes with, with all the institutions includes, all these new institutions of government includes new institutions for military legal power as well. Okay, I've been talking for a while and we're coming up on 1:40, which is sort of our point to have 20 minutes of Q&A. And this is a pretty good stopping point as well. I could talk a little bit more about the models of change over time, but this is a decent stopping point for our look at the kind of establishment of military justice systems and what explains some of those from the beginning. So I'm going to stop the screen share and ask Dr. Holloway to jump in as moderator and see what else we can talk about.
Now I'm unmuted. Thanks so much for that excellent presentation. That's all very fascinating. We do have some questions in the queue, but before we turn to them, I want to exercise the moderator's prerogative and just throw out a question that came to my mind as I was listening to you. So tell me what you think about this. It makes sense to me intuitively that human rights would be better secured under a system of civil justice rather than military justice. On the other hand, I mean, I just wonder, are there any outlier cases where, I mean, there could be countries where the civil justice system is very corrupt. I'm just wondering has it ever been the case that you might be better off in a military justice system in some extreme case? And I guess that relates to the question, which you know obviously a lot more about than I do, but my vague impression from studying these things in the distant past is that in some cases, the military has taken over a country in part because there was a widespread feeling that everything was out of control or things were falling apart. So anyway, I just throw that out there and then we can turn to the other questions.
Yeah, so first of all, thank you for that question, Dr. Holloway. Yeah, this is a really important question, one that my co-author and I have fielded before as something in the formative era of doing this work, that we had to recognize that we shouldn't assume that civilian courts and civilian justice is better or flawless or any of that sort of thing. So I can't say that it's something that we really deal with analytically so much in this work as it is something that we write about in the first couple of chapters, is saying that we acknowledge the fact that, as you say, in many places, the civilian judiciary may be under-resourced, it may be corrupt, it may lack judicial independence itself, all this sort of thing. And so there's no guarantee that civilian courts are great, and there's no guarantee that military courts can't do their job effectively either. And in fact, some in terms of, so again, this is sort of beyond the scope of this particular work, but when it comes to international law and international conflicts and so on, there is a line of legal research that says that there's really no particular reason why military legal authorities are somehow not accepted, why civilians could not be under military justice in circumstances of international conflict and this sort of thing, if that is the only legal framework in the place where there is military occupation or something like that, and that it's not incompatible with international law, I think is the concise way of putting that. I think the question of whether there's some case you could point to where you'd say, well, actually people are well off under military law. I'm not sure there is an instance like that I can point to and say, okay, based on this work, we can say that in this one particular place or this one particular circumstance, things are actually better. But I think that's mostly due to the sort of X factor being the civilian system, right?
Mhm.
It would be an interesting project and probably a valuable research effort to try to kind of do that half of this as well, where, okay, we have this set of information about the military courts, but we could try to marry that up with something about civilian courts and see, what the interplay is like among them. Because again, civilian courts do in fact play a large role at times, at least, or they have the ability to play a large role in reform of military courts, because oftentimes that is how these things get challenged in the first place, is that somebody has been put into the military justice system and tries to challenge that in the civilian legal system. So, and in fact, that's the case in a place like Pakistan, where there have been many court cases going through the civilian system to try to deal with the constitutional question of whether the military has the right to have somebody on trial, have a civilian on trial, that sort of thing.
Okay, thanks. We do have questions coming in now through the Q&A feature. So let me throw some of those at you. Here's the first one. The questioner asks, did your research show if one geopolitical area experienced a higher rate of military overreach? And if so, does it correlate to a more authoritarian role, or maybe like more authoritarian history in that area?
Yeah, I think this is one of my students, and I promise I didn't pay him to ask this, but this is this is a very good question, and it allows me to perhaps go back to the screen share and show. Yeah, I can go ahead and show you these figures for each of the regions of the world. And so, Jeremy, you asked that was there a region that was particularly good, particularly bad? Dr. Holloway, help me out here. How was it phrased? I can't find the...
Does your research show if one geopolitical area experienced a higher rate of military overreach?
Higher rate, yeah, okay. So, so you can see this for Western Europe, where, as I say, for the most part, we're talking countries that have been long-standing democracies. Things look fairly good for most of this time period, 1800 onward. I mean, with some obvious exceptions, but things getting better over time and everything. But you'll notice that a region like Latin America, as it's depicted here, this is one area of the world where things have been, where this has been a really significant and consistent problem. And you can see that, from the period of independence in the early 1800s to, into the into the 20th century, things were getting gradually worse, and then worse and worse into the 1950s, 1980s, this Cold War era, in which militaries either were directly in control of their countries, or they were empowered in one way or another to fight a quote unquote internal subversion, and used their courts to do so. So certainly Latin America would be one of those regions that we could point to. Although, again, being a little bit more optimistic here, you can also see a pretty strong, post democratization, post Cold War effect, whereby things are in fact better now than they have been. Asia and the Pacific looks like this, whereby, again, pretty significant percentages of the countries, although I should point out here that this is a different timeline. This starts in 1946 rather than the 1800s. So a shorter timeline, but you can see the depiction of those different sort of different categories. Eastern Europe, this was an interesting finding, just as a matter of the kind of observation of Eastern Europe, again, from post-World War II onward, that during communist rule in these countries, it was actually pretty rare that the military itself had exceptional legal powers, because this was all under the control of the party, under the control of one party state, and so on. Africa looking like this, whereby it's not as bad as Asia and the Pacific, not as bad as Latin America for some of those time periods, but you still see some variation. And again, that general trend of things being better now than they have been in the past, with the exceptions. So, I think the brief answer to your question, Jeremy, is that Latin America historically has been the worst in terms of has had this as its biggest. The problem has been at its greatest in Latin America, where you see really high rates of military overreach.
Okay, another question asks you, Dr. Kyle, to become prophetic. Can you look forward in time and point out which states you think might see backsliding, partial or full, in the near future? Yeah, so I cannot be prophetic, but as my students in the graduate comparative seminar know, we do try to develop theory that can explain cases beyond the cases that we have already studied. Whether we turn out to be right or not, that's up for the observations later on to tell us. But I can tell you that from our causal explanation of what explains backsliding, essentially countries that are facing some sort of security threat are the ones that are at greatest trouble, at greatest likelihood for trouble, or greatest likelihood for backsliding, especially in places where there are relatively weak civilian institutions. The potential for backsliding is really high. And so again, a place like Pakistan, a place like Thailand, these countries that have been through many, many rounds of democratization and military rule, you put a security threat in there as well, and it's almost guaranteed that they're going to backslide from whatever they're, if they have managed some reform, there's a very high likelihood that they're going to backslide. Mm-hmm. I would add to that, however, and I think this is kind of a cautionary tale about longstanding democracies and countries that we would consider to be pretty durable in this regard, that what my co-author and I have observed about the conduct of countries in these circumstances is that even established democracies, when facing a security threat, oftentimes turn to the military. And I would argue, there's evidence to say that increasingly they turn to the military to try to handle these kinds of problems. And empowering military courts to deal with them is one of those tools that they reach for. I think that's something that's very dangerous and something that we have to be watchful for as citizens, and not allow this to be something where the kind of public pressure of democracy that is a good thing, it's how democracy works, is also the thing that allows us to wind up destroying democracy through fears of something like terrorism. To say, oh, well, the government must do something. And suddenly what the government decides to do is to empower military courts, because that is the sort of thing that we observe in lots of places that face these kinds of security threats. That it's this kind of sense of public outcry for, Dr. Holloway, as you were referencing in your opening question, that where civilian judiciaries are not trusted, where they're seen as incompetent or not delivering on actual judicial outcomes, the police are not trusted in everything or anything like that, or not effective, not competent. The public outcry for something to be done combines with the democratic imperatives of leaders trying to get elected and get reelected, such that they're looking for quick fixes. They're looking for something that will happen, that will fix the problem before the next election, so that they can get elected or get reelected. Or if the incumbent isn't doing a good job of this, then you better believe there's going to be some sort of challenger that says, just have the military kill people. And this is the kind of democratic trap that potentially exists.
and potentially, you know, empowers military forces to do this sort of thing, that that can undermine the rest of the system.
Mhm.
So I can't be prophetic, but I can give you warnings.
Okay, good. Warnings that are well taken. There's another question that is similar to that one, but more general. It says this, and to get it right, I'll read it. Recent research seems to have shown a certain amount of democratic backsliding worldwide. Your chart shows that full subordination of the military to the civil authorities increased throughout the 20th century. Is the world currently at risk in the last decade or two of returning to more military overreach? Or if there is democratic backsliding, is it happening in other ways?
Yeah, I think in short, democratic backsliding is happening in other ways, but it may also be in, you know, we may also be observing slightly different things, because Freedom House and Polity and that sort of thing are focused on slightly different things in terms of what they're assessing in order to make their judgments. So they're assessing things about you know, ability to express an opinion, civil liberties and civil rights scores, that sort of thing. And a lot of that is kind of, I mean, we use those in order to collect our, or to define our cases and so on. But I think what we're looking at in terms of military behavior is actually separate from that. I think one of the things that's maybe valuable in this regard is just to understand that these kinds of military legal prerogatives are sticky, in the sense that there is a tendency for whatever exists now to continue to exist. And you could say that at any time point, right? That reform is pretty rare, and reform, or backsliding for that matter, like reform and backsliding, those changes are not happening all of the time. And the changes, as they do happen, do require some amount of action to get there. So you know, it's something that, as I say, like with the backsliding, there are these particular circumstances in which countries are really in danger. With regard to reform, it's a little more, you know, you can see that it takes a coalition of forces to change the way these things work.
Mm-hmm. Yeah, that's a pretty helpful clarification, it seems to me, because you could have democratic backsliding or erosion of democracy that doesn't really go anywhere near military rule. It could be oligarchy or one party state or something like that. Yeah.
Yeah, and actually, as long as we're on that topic and the sort of clarification about recognizing that civilian government and for that matter, military legal subordination should not be taken as synonymous with liberal democracy, because one of the things that we have observed is that some of these populist leaders that have really come to the fore in the last couple of decades, basically, have their own political incentives for subordinating the military to their own authority, or for, you know, to kind of cut out their political power that might have previously existed in the country. So Erdogan in Turkey, for example, is engaged in a lot of reforms of the military that would show up as positive in our data in terms of full subordination and so on, but obviously is not necessarily a positive thing for the country's democracy overall, and this sort of thing. Same thing, Lukashenko in Belarus, Rafael Correa in Ecuador. You know, some of these reforms that look good in our data are happening in concert with other developments in the broader political sphere in those countries that are not good. Things that are quite negative.
Yeah, I guess I think the old example that I suppose, I'm not an expert on this, but I suppose that the Soviet military was subordinate to the Communist Party of Russia, but it wasn't a democracy. So there's a lot of other factors to consider. Hey, here's a short one. We're getting near the end of our time, but we have a couple more questions. One participant asks, are any of the three types of situations you described more responsive to the authority of the World Court?
So if you mean specifically the International Criminal Court,
I think
or
that's what they mean,
okay,
but they said World Court. Yeah.
yeah. So the short answer is no. That basically the interaction between those kinds of international courts and well, any domestic courts, military or civilian, is always filtered through the prism of sovereignty. And so if there's some reason why the state has a reason to reform, maybe they'll pursue it in response to international court rulings that condemn the current practices. But if they want to ignore a court ruling, they can, and they do. And probably the best example of that dynamic is not so much with the International Criminal Court, because I'm not aware of any particular cases that would have really spoken to this issue. But in Latin America, it has been the case that the Inter-American Court of Human Rights has issued rulings that have pushed for or have advocated for reform in Mexico, and Mexico pursued reform. Same thing has happened for Brazil, and Brazil has ignored it. And so that's, you know, sort of the long and the short of that sovereign status of a state being able to say, yeah, we hear you, but we don't care, or, you know, you don't really, you know, we don't really recognize your authority in the first place, you know. So international courts, for you know, unfortunately, tend to have very little power to actually push for something like this on their own. In order not to be totally dismissive, though, of the power of those kinds of international courts, is that obviously those types of rulings can give domestic actors, activists, civil society organizers, and government officials a rallying point, and say, you know, look at this particular case, look at our position in the world and the way it's being eroded by, you know, our failure to live up to these standards and so on, and can use that in their own advocacy. So we shouldn't totally dismiss the role of international courts and so on, but at the same time, if a government wants to ignore it, they can.
Okay, thank you. It seems that we have reached our time limit, so I think we should conclude on that interesting note. And I wish we could give a round of applause, but we're not here in person, but I would do it. I'll do it. Thank you, Dr. Kyle, for that very interesting presentation. I learned a lot. I think all the participants learned a lot, and the Q&A was very good too. So I also want to thank everybody for participating. And I think we may have a recording of this that will be available at some point. So we'll keep an eye out for that.